Yes, sir.
To maintain court order and silence, please.
My name is Olinga. I appear alongside Mr. Koimburi for the state. Ms. Olinga. Olunga, O-L-U-N-G-A. Appear alongside Mr. Koimburi for the state.
Please approach your honor. My name is Ndegwa Njiro. I appear alongside Mr. John Jomo.
Present, yeah.
Ms. Sarah Chege. And Mr. Mela Mageto.
Present, Your Honor.
We appear for the accused person.
Your Honor, this matter is coming up for plea. And if I may lay basis, the accused has been brought before this court with a charge that had been withdrawn. The case was Kiambu NCCR E775 of 2021. And the case was withdrawn because the accused failed or neglected to come to court. And thereby the prosecution applied for forfeiture of cash bail.
You know, the procedure, the DPP.
I'm laying a basis answer.
I'm
You'll have your time.
I'm on my feet.
You'll have your time.
I am on my feet. The procedure that the DPP is introducing before you this morning is alien to these proceedings. The procedure that I know is that once an accused person is brought before you, Your Honor, he takes plea. There is nothing called like laying the basis, because what the DPP is attempting to do is to dissuade this court and prejudice the mind of this court. Let the DPP do what is done in normal circumstances. These are normal case provided for under the penal code. Let her have the accused person take plea. There's nothing called laying the basis, and she cannot introduce new procedures.
Before we proceed, Your Honor, let me correct the case number.
Okay, that's the case number, but the proceeding.
Okay. No, no, that is the previous one. You can handle the paper.
So we proceed.
Yes.
Judge Koimburi Ndongo.
You have a first count?
Before the accused persons take plea, we have an objection.
To what?
To once the accused person pleading to the charges before you. And Your Honor, if you may allow me, then I'll address you, then my colleagues will equally address you on the objection.
Counsel is contradicting himself. He just told me to sit down and to proceed with the plea,
Yeah.
and that is the procedure.
Because Your Honor,
Yes.
what you want to do is to bring the abuse.
You can bring it after
The
pleading.
abuse that the DPP is perpetrating through this charge sheet and the mischief.
Well, let us take the plea first.
Because,
All that
Your
can
Honor,
come after the plea.
Our objection is on this basis, Your Honor. It's under sections 87.
I will say it like this. Let's just do the plea and then I'll listen to everyone.
Yes.
Are we together? Your client has a right to refuse all the charges.
That's correct, Your Honor. We are not even objecting to him pleading. What we want to bring it to the attention of the court is the mischief being perpetuated by the DPP. For one reason, Your Honor, as correctly put by DPP, this court was previously seized of similar matters.
But unless if you want to respond to what she's saying, then I will have to allow her to finish talking and then you respond. Would that be okay with you?
Unless therefore she's making an application to have this new charge terminated, then I will respond. But as long as she's making an application for daily basis, Your Honor, it fights itself.
We
no
stopped
place
that, Your Honor.
in the smoke in the
He's
criminal
taking us back.
procedures.
We stopped that. Let us take
Your Honor,
plea.
may I address you? Then you can make a determination as to whether I am sufficiently addressing your points of law, or we go to the taking of the case.
Okay, let me allow you. Let's proceed the plea and then I'll listen to all these allegations from both sides. Are we together? Before I make any further orders.
Maybe just a bit more
You said I
intervention.
follow the procedure, let's follow it.
Yes.
Yes.
By taking plea and then I listen to all this.
Yes, Your Honor, as you follow that procedure, the reason why my colleague is raising this issue, this charge sheet has been furnished to us. We have a copy of the charge sheet. And all the counts, if you look at count number 7, as he takes the plea.
Your Honor, there is nothing before you. Before he takes the plea, you cannot
It's a
proceed to
matter,
anything.
it's a matter that is relevant.
Let
Your
us
Honor,
follow the
because-
procedure, please.
Because this plea or the charge sheet is introducing a matter that is already before the court. We have been cited a case number
No.
E715 of 2021, and that file is not before the court. So that the question that the court should be asking itself, even as you look at the plea, is what the status of this particular matter. We are bringing a new charge sheet with a new charge, a new count on a matter that is already before the court. This file has not been available to the court.
Counsel is
so that we
misleading
can
you,
also
my
have the
Your
advantage.
Honor. Counsel is misleading
Let
you.
me
There is
just-
nothing
let me-
before this court.
let me
No,
just finish.
I will not allow him to mislead
Let me
the
just
court.
finish.
Because the matter was withdrawn,
Your Honor,
and this
let
is
me
fresh.
just finish. This is court record.
Please, let's have-
Your Honor, this is the court
Yes, the
record.
court.
This was the
You
charge
don't
sheet
have courtesy as well.
that between 29 July 2021 and 29 August 2022 at Kiambu within Kiambu County. Kiambu Chief Magistrate Criminal Case number 715 of 2021. That is part of the record of the court. Even if that matter, Your Honor, is withdrawn, that is still part of the record. So that, Your Honor, the accused person is required to plead to a charge on a matter that is not before the court. He has no advantage of saying yes or no on a charge, on a file that should be before the court. For him to respond to this, Your Honor, as a plea, he's supposed to say, I plead guilty or not guilty. How can he respond to this particular charge on a file that is not before him? Has he been given that particular file, Your Honor?
Okay, if that's enough, thank you. Let's proceed the plea and then I'll listen to all this and actually.
Your Honor, the concern is, how is
We are
it to
proceeding
respond
with the plea.
to this particular charge and count
You know,
without the file being in court?
There's also something else, and I respect the directions of the court. What happens to a case that has been withdrawn under section 87A? Is the DPP supposed to bring new fresh charges, or is the old matter revived? That's a question of law, Your Honor, I wish you to determine.
Please.
You know, is it that we are not addressing a question of law?
I want us to follow the procedure. Let's do the plea and then I'll let.
But how about the abuse being perpetuated by the DPP? Can the court close its eyes to the abuse being perpetuated by the DPP? Because that is the question. The abuse being perpetuated by the DPP, we cannot allow it to pass the eyes of the court.
Alright, let me do the simple matter and then I'll come back to you.
Most obliged.
James Monday.
Yes, we have conference, but perhaps before you do that, we place Mr. Mans or Senator Otterbeck for the accused person. And our conference has resolved to indicate to the court that we record the following preliminary objection in light of section 87, paragraph A of the CPC. While looking at that, Your Honor, the specific objection is in respect to the proposed charge of count 7 of the charge sheet. And this is the basis of our objection. I'll address you on part of it, then my colleagues will address you. Your Honor, as correctly captioned by count 7 of the charge sheet, the accused persons before Your Honor was previously charged of the same counts. That is count number 1 up to 6 in criminal case E715 of 2021. Subsequently, Your Honor, the DPP exercised his powers under section 87 plus paragraph A and withdrew that case. He has now again, Your Honor, appeared before you under the same section again, exercising his rights to charge for the same offenses that had previously been charged. And when Your Honor, we have no objection to our client taking lead in respect to count 1 to count 7 to count 6. Our objection is in respect of the mischief being perpetrated and the abuse of power being perpetrated by the DPP by invoking section 121I of the Penal Code. To that, Your Honor, in that respect,
121 of it?
section 121, subsection 1I of the Penal Code. And the charge reads, failing to attend court contrary to that section. Where did he fail to attend court? In that case that was withdrawn under section 87A. So our simple application here, when a case has been withdrawn under section 87A, is the DPP permitted by the law to introduce new charges in the same file, or is the DPP limited to the charges contained in the initial file? You know, I leave it to Mr. Jomo and Mr. Manza to proceed with the colleagues.
The observation that I had made before, as regards count number 7, that has been framed by the DPP, is on the difficulties that are being advanced prejudicial to the accused person to respond to that particular charge. Because if you look at the particulars of that offense, is that it is referring to a matter 715 of 2021. John. So that what is the fate of the accused person in saying, responding yes or no, even keeping quiet, as regards that particular count? That is the inability that faces the accused person at this moment, because he doesn't know the particulars to which that offense relates. The only fair procedure, because the accused person is entitled to a fair procedure and a fair hearing, is that those issues of 715 of 2021 must be dealt with within that particular case, so that he can come and tell you that the reason why I did not attend court, assuming that the matter was withdrawn because of failure to attend court, was because of 1, 2, 3 reasons. And it happens all the time. We don't know, as we stand here, or he doesn't know, whether there were warrants in place that he can respond to say whether it is true or not true. He does not know whether he had been served with any warrant, if any had been issued, so that he can again say it is true or it is not true. In summary, Your Honor, it is not possible for the accused person at this juncture in time to respond to any allegations in 7/15 of 2021 without having the benefit of the record of that particular file, so that as he can respond to all the other offenses, this particular count number 7 will be a difficult position for him that he cannot respond to. In all fairness, Your Honor, bringing this particular count at this point in time without any information at all would be highly prejudicial and will flout the rules of fair procedure and his constitutional right to fair hearing. We oppose that particular count and charge being pleaded to.
Your Honor, your kind submission, Your Honor, a matter is stated under 87A of the CPC means that it had already been pleaded to and the plea responded to. And in this matter, it was a plea of not guilty. So, Your Honor, in the event that matter is reinstated, then it proceeds from where it was left and from the record of the court as of the time it was withdrawn. So if there's a particular file and there's a particular matter, Your Honor, what needs to be done is to bring the person back to court and then proceed with the hearing of that particular matter. I'm aware the prosecution is allowed to amend charges anytime, but that should that happen, then, Your Honor, then there should be a totally new charge. It's a totally different file now if you are to bring up matters. Although you can amend, Your Honor, under the law, it doesn't mean you have to plead again. We have to know what is the status. And for purposes of Article 50, Your Honor, then the accused person has to be accorded an opportunity to explain themselves as to any times he may have missed case or the court case, and also to ascertain whether the days the accused person was not present, whether the matter had already been withdrawn or had been negotiated for the whole Your Honor. We therefore plead with you, Your Honor, that we proceed with the original case, and should there be any need to amend charges or add charges, then there be a proper notification to an accused person so that before they plead, they have already been notified of their charges.
Allow me to summarize by referring you again to section 87 and the last part of it. It says, if it is made before the accused person is called upon to make his defense, he shall be discharged. Now that's how we begin, a comma. But discharge of an accused person shall not operate as a bar to subsequent proceedings against him on count of the same facts. What is before you does not square out with the requirement of section 87, paragraph A. What is required is that he shall be prosecuted, subsequent proceedings against him on account of the same facts. Does the charge sheet before you, is it a new charge sheet, or does it present the qualifications and the principles and the tenets elucidated by section 87A? Number 2, and the final one. Is this an amended charge sheet? so that then we understand that the DPP has exercised that right. We are most obliged.
Thank you, Your Honor. I wish to submit that the preliminary objection has no basis. The previous case against the accused person, that is file number 715 of 2021, was withdrawn under section 87A. Your Honor, the same section of the CPC gives the DPP power to reinstate the case and does not limit the DPP to conduct further investigation and even bring new charges based on the same facts. I must submit that the charge they are contesting to is a charge that has been brought, which is within the facts that the accused person was charged in count 1 to 6. Nothing in law stops the DPP from amending a charge sheet. And in this case, we are not amending a charge sheet. This is a fresh charge. And that is why the case has been given a new number. It is number E343 of 2024. So once the matter has been withdrawn, the previous number ceases to exist. And we have brought accused person with same charges, and further investigations were done, and additional charge was added. So, Your Honor, it is not prejudicial for the accused person to take plea and answer to the new charge. He will have time to respond. We are going to serve him with the statements of the witnesses. He's well represented by a team of advocates who are even senior than me. I can see Mr. Manzo here, my good friend. They'll represent him and be able to respond to the charges. So I don't see that anything that stops this court from taking plea. It's our submission that the court allows the plea to be taken to enable the accused person answer to the charges. That would be all.
This is what I say. Maybe I'll be late for tomorrow. I have my opinion, but I want to consult with the law.
Yesterday, Your Honor, when our client was arrested by the DCI, when we appeared before and we were making an application for bail, we were laying the basis for it. You know, when our client was arrested yesterday, he was presented before the DCI, serious crime unit. The offense that we signed the precautionary court statement to was about cybercrime. I'm laying the basis for my application.
I don't know that one, Your Honor. Please handle the case before the court.
Okay, then I want to say, let me just take a few minutes and do the ruling and so that we can move forward together.
Yeah.
That would be fair.
Yes.
So the idea is not your way.
Yeah, that would be fair, because you would have laid the basis how the DPP is abusing his powers and representing other interests other than the case.
Okay, so my ruling is basically touch on the facts, the issues raised.
Yes, specifically, they specifically count number 7.
Well, number
We are
7
most
also
obliged.
affects the other counts.
We are most obliged.
In 30 minutes,
We are most
but
obliged.
I have to give the talk to my colleague. So once she's done, we'll back.
We are most obliged.